On behalf of the society, I would like to thank all of you for your scholarly efforts to give early Black attorneys their overdue recognition. The society is very proud that you've chosen the Journal of Supreme Court History as the forum for telling their remarkable stories and shining a light on their legal careers. These attorneys deserve to be better known as pioneers of the Supreme Court bar, and the Society is pleased to hold this discussion today as part of our ongoing mission to publish original research on topics that have been overlooked or understudied. Thank you all for your contributions, and thank you, Tim, for convening this.
I'm wondering if each of you could talk a little bit more just about how that freedom movement intersected and overlapped with the struggles and the sort of barriers that each of these men faced, each in his own time.
Well, I'll begin with Waring. He is, he's a true pathbreaker. There have been multiple challenges, legal challenges, to integrate the Maryland bar, and it finally clicks with him, and he is immediately put to work. He's sort of the de facto in-house counsel for this Brotherhood of Liberty, and they set about challenging various discriminatory laws. And so he has his full plate, and he, in many respects, makes arguments that were not successful immediately, but laid the groundwork for a later successful effort, sometimes argued by a white lawyer before the same court a year or two later. And all of a sudden, now the argument is, fares somewhat better. But they, the challenges, I think it can't be underestimated, not just the challenge to become a lawyer, to be admitted, because let's face it, all these lawyers are being admitted to their respective states by reading the law generally, by submitting themselves to an examination by either a judge or a local bar committee appointed by a judge. And, this can be a very subjective process and a much more difficult and involved process for the Black aspiring attorney, the Black candidate, as opposed to the white candidate for whom it's really, perfunctory. And then when you're practicing, you have to contend with arguing in front of white judges, white opposing counsel, all white juries. You have to contend with doing this in courthouses where you can't use the facilities that are open to, members of the white public. And, you have to contend with all of this. In fact, in many states, well up into late in the 19th century, there were statutes in place, including in states like California, where the testimony of a Black witness was not acceptable if testifying against a white litigant. You had to find some other witness to prove up your case. I mean, I've tried a lot of cases in 33 years as a lawyer. You go up into that boxing ring, it's tough. It is even tougher to have one arm tied behind your back. Many of these early Black lawyers were having to fight that fight, sometimes seemingly with both arms tied behind their backs.
Yeah, if I may, Rock's case is probably because he was so early on in this, was particularly challenging. I mean, 4 of the justices on the court that Chase needed to convince of Rock's appropriateness for admission to the bar had agreed with Pawnee on Dred Scott. And then you had Nathan Clifford, who's considered doughface, so a Northerner with Southern sympathies. David Davis, who famously said, a Negro can never be elevated to social and political rights in this country, and all wise statesmen know it. So those are some pretty difficult odds to overcome. So further to John's point, it wasn't easy. It's definitely, like I think John said, perfunctory. The 3 years of good practice in your home state and the recommendation. from from a current member in good standing with the Supreme Court bar. But that wasn't so easy to get that for these lawyers.
Yeah, I would say for Jones, there's really two thoughts I have. One is he lived in Issaquah County, Mississippi, which is a small county that had overwhelmingly Black. I think it was 90% plus Black. The neighboring counties were Bolivar and Washington County, which were also largely 85% Black. And his practice, the cases he brought to the Supreme Court came from those counties. Those two counties, I think, were second and third in the country in lynchings in the whole, both in the 1890s and in the period up until 1950. And, you know, at one point in before he was practicing law, he spoke at a rally, a political rally for some Republican candidates. And there was a group of Black citizens from the neighboring area who were coming to the rally and were set upon in a well-known incident that a lot of historians have recognized. They were set upon by some white Democrats who were trying to keep them from being involved in politics at all, and murdered. Basically, they shot, I think, the three of them, wounded a couple of more. Actually, the newspaper report said they were looking for a Black politician, and I've always wondered whether it might even have been Jones himself, since he was scheduled and did speak at the rally. But he definitely faced threats of violence in his career, and how he avoided that, and how he got his cases to the Supreme Court. One of his clients, Gibson, actually, well, he was tried 4 times. Jones actually got his first conviction reversed by the Mississippi Supreme Court, but not his ultimate one. So on the one hand, there's that. On the other hand, I would say something that has intrigued me is that, as I said, Anselm McLaurin, who was a later governor of white supremacist Mississippi in 1896 to 1900, and then a U.S. senator appointed by the state legislature, was his mentor, and he'd studied law under McLaurin in the 1880s, and he wasn't the only one. There was another Black lawyer, well-known man named Samuel Beadle, and actually when Beadle went into court to try to be examined by the judge to join the bar, the judge refused to do it, and McLaurin apparently fought for him and somehow got convinced the judge to hold another hearing, and it was a pretty uproarious hearing. There was a lot of uproar at the hearing, but he ended up getting admitted. So there was that also, and the role of that, whether that connection with McLaurin helped him or what, that's for further research.